Attorney General's petition, 19th and 20th respondents in Mr. Moraro Omoke's petition, and 7th respondent in the IEBC petition. Thank you.
Good morning, Your Ladyship, the Chief Justice, Honorable Judges. My name is Evans Ogada. I appear alongside Mr. Elisha Ongoya. We are on record for Justice Juma and Isaac Ogola. These two respondents appear at number 11 and number 12 of petition E16 of 2021. Thank you.
Good morning, Your Honors. My name is Isaac Aluochier, the 70th respondent in Moraro Omoke's petition of appeal, 21st respondent in the Attorney General's appeal, and the 78th respondent in the IEBC appeal. Thank you.
With your kind permission, the Honorable Chief Justice, Mr. Steve Ogola, here to pick a ruling on behalf of the proposed interested party, the Party of National Unity, in the AG's petition of appeal.
A very good morning, the Honorable Chief Justice, my lords, my ladies. My name is Odongo Brian, here to take a ruling for the proposed Amishi, Professor Rosalind Dixon, Professor David Landau, and Gautam Bhatia. Most obliged.
May it please you, my ladies, my lords. My name is Orlando Lembo. I appear together with Sally Omoto, Ms. Sally Omoto, for Professor Charles Fombard and Dr. Adam Keabebe, who are proposed amici. And I also hold brief for Professor Migaya Ketch, who is our proposed amici.
Good morning, my ladies and my lords. I'm Barbara Kwanga. I appear for the proposed intended amici, Professor Richard Albert and Professor Yaniv Rosnai, Professor Yaniv Rosnai, in a ruling in the AG's appeal.
Thank you. I think we have taken the quorum of all council and parties present. Directions, like I said, were given on filing the responses, which were filed. We also received 7 applications filed in the 3 petitions. We received 4 applications for parties seeking to join as amici curiae, filed in petition number 12 of 2021. We received 1 application for recusal filed by some members of the court, seeking for some members of the court to recuse themselves. in petition number 12 of 2021 by Mr. Isaac Arwoche. We also received one application for joinder as an interested party in petition number 12 by the Party of National Union or Unity. One application for consolidation of the petitions filed in petition number 11 of 2021 by Duncan Oburu Ojwanga. We deliberated on those applications as a court and considered the written submissions pursuant to Rule 4 and 31(1) of the Supreme Court rules, and the court will deliver our decision on those applications. On the application for recusal, I will request the Honorable Justice Philomena Mwiru, the Deputy Chief Justice and Vice President of the Court, to read the court's decision.
I'm most obliged, my Lord the Chief Justice. This is the application for the recusal of 2 of 3 judges of the court by Isaac Arwoche, and this is the ruling of the court. Upon perusing the notice of motion application dated the 26th of October 2021 and filed on the 27th of October 2021 by Isaac Arwoche, who is the 21st respondent in petition number 12E016 of 2021, seeking a recusal of Honorable Justices Mohamed Kadha Ibrahim, Smokin Wanjala, and Jokindongo Susana from hearing and determining the petition of appeals arising from the judgment of the Court of Appeal delivered on the 20th of August 2021 in Civil Appeal number E291 of 2021 as consolidated with Civil Appeal number E292 of 2021, E293 of 2021, and E294 of 2021. Upon reading the grounds on the face of the application, the applicant's supporting affidavit sworn on the 26th of October 2021, the written submissions by the applicant dated the 26th of October 2021, the affidavits and submissions filed on the 27th of October 2021 respectively, and in particular the grounds in support of the application, mainly that A, the applicant launched with the Judicial Service Commission a petition on 6th of April 2016 for the removal of 6 judges on account of a breach of the Code of Conduct prescribed for judges and for gross misconduct, which petition is still pending, the Judicial Service Commission being non-responsive, leading the applicant to institute petition number 301 of 2016, to wit Isaac Arwoche, Polo Arwoche versus Hamed Isaac Hassan and 24 others, 2016 EKLR. B, the applicant's right to fair hearing under Article 50, Subarticle 1 of the Constitution is non-derogable and has to be balanced with the right for other parties in arriving at a just conclusion, which right cannot be superseded by the doctrine of necessity and the duty to sit as enunciated by the court in the case of Jasbir Singh Rai and 3 others. and in the case of Gladys Bosch-Cholet and the Judicial Service Commission. C, it is in the interest of the administration of justice that the court be objective and impartial, pursuant to Article 73, Subarticle 2B, and Article 166, 2C of the Constitution, requiring each judge to observe the guiding principles of leadership and integrity, including objectivity and impartiality in decision making. And considering the grounds of opposition dated the 1st of November 2021, filed by Paul Mwangi and Company Advocates on behalf of the 20th respondent, the Building Bridges to a United Kenya, National Secretariat of the BBI Secretariat, and Raila Amolo Odinga, the 23rd respondent. The said respondents oppose the application on inter alia the following grounds. A, the application is an afterthought. It is ill-conceived and intended to convolute and delay the hearing and determination of the petition. B, the applicant has not demonstrated and or adduced any such evidence in support of the allegations on bias by any of the cited judges. C, the application is self-defeating for the reason that whereas the applicant cites 3 judges for recusal, he seeks the recusal of only 2 of them. D, the application offends the doctrine of the duty of a judge to sit. And further, considering the applicant's further submissions dated and filed on the 3rd of November 2021, in which he proposes that pursuant to Article 159, Subarticle 2C of the Constitution, the appeals instead be heard and determined by arbitration, conducted under the supervision of the court, the modalities of which can be dealt with during the case management conference. The court took the liberty to establish from the Judicial Service Commission the existence of the applicant's petition against the 3 judges. The Judicial Service Commission reports that it does not have evidence of ever having received any such petition, and there's nothing on its records. The 3 judges are similarly not aware of the existence of any such petition for their removal filed with the Judicial Service Commission by the applicant. In the above context, therefore, we make the following determination. A, the applicant has not adduced any evidence as to the nature and contents of his alleged petition to the Judicial Service Commission against the judges to enable the court determine the extent to which the applicant is aggrieved against each of the named judges. B, in the absence of the petition by the applicant against the judges before this court, either directly or through the Judicial Service Commission, the possibility of bias or impartiality we find is far-fetched and speculative. C, the applicant has not spelled out any specific allegation that is likely to impair the judges in dealing with the matter against the applicant, as the applicant indicates willingness to have either of the 3 judges he's accusing to be part of the bench and to have his petition resolved through alternative dispute resolution mechanism. D, the applicant having instituted his petition against the judges to the Judicial Service Commission, the same should be allowed to take its course, as the Judicial Service Commission is an independent constituted constitutional body and operates separately from this court. Indeed, the applicant indicates that he took out proceedings in Isaac Aloch Polo Alocher versus Hamed Isaac Hassan and 24 others, which proceedings we have not had sight of and in any event are not subject of our determination. E. Article 25 of the Constitution protects the right to fair trial under Article 52 of the Constitution, which only applies to accused persons in criminal proceedings. This is distinguishable from fair hearing alluded to by the applicant under Article 51 of the Constitution. F. The doctrine of necessity and duty to sit, as set out in the case of Jasbir Singh Rai and that of Gladys Bose Sholay, and appreciated by the applicant, necessitates that the present matter must be heard on its merits. This is owing to its public interest nature. We note that none of the other parties in this matter has supported the present application, and as rightly noted by the 20th to the 23rd respondents, this court under Article 163(7) of the Constitution and Section 3 of the Supreme Court Act is mandated to make authoritative findings and settle points of law such as those raised in the appeal before the court. G. The issue as to whether the necessity and duty to sit amounts to derogation of the right to fair hearing under Article 50, Subarticle 1 of the Constitution does not arise under these circumstances. H. The judges having been appointed in their present positions under the Constitution, including satisfying the provisions of Article 73(2)(b) and Article 166(2)(c) of the Constitution, their impartiality and integrity can only be negated following due process, which the petitioner alleges to have invoked, but which is inconclusive. 7. Having found the foregoing determination, we make the following orders. 1. The notice of motion application dated the 26th of October 2021 lacks in merit and is hereby disallowed. 2. There shall be no orders as to costs. Orders accordingly. Thank you, Chief Justice.
Thank you very much, the Honorable Deputy Chief Justice, for reading that ruling decision of the court. I will now go to the application for the joinder of an interested party, and I will request the Honorable the Justice Joaquin Dongo, Supreme Court Judge, to read the court's decision.
The Honorable Chief Justice, Deputy Chief Justice, Justices of the Supreme Court, Council, this is the ruling of the court on the application by the Party of National Unity to be enjoined as interested party. I'll read it in summary. The full ruling will be available after this. Upon perusing the notice of motion, application dated 12th October by the applicant, Party of National Unity, and noting the applicant's filed submissions, also noting the opposition of the 7th, 8th, 9th, 13th, and 18th respondents, And considering all arguments and the law as set out in the Trusted Society of Human Rights Alliance and Mumo Matemo, and also in the case of Francis Muruatetu and others, we find that the applicant has not met the threshold for admission as an interested party, as it has failed to establish a personal interest or stake that is proximate enough to occasion any prejudice to it if not enjoined in these proceedings. We therefore find no merit in the application and we accordingly dismiss it. There shall be no order as to cause.
Thank you, Honorable the Justice Njoki Ndung'u, for delivering that decision on behalf of the court. I will now request the Honorable Mr. Justice Renaura, Supreme Court Judge, to read the court's decision on the joinder of Amici Curiae.
Thank you very much, Chief Justice. The first ruling is by the first application is by Professors Rosalind Dixon, Professor David E. Lando, and Professor Gautam Bhatia. All the applicants seek to be admitted as amici curiae in petition number E016 of 2021. We have perused the affidavit in support, the submissions by the applicants, their reliance on the case of Trusted Society of Human Rights versus Mumo Matemo, and Raila Odinga and others versus IEBC. We have considered the grounds of opposition by the 20th and 23rd respondents. We have looked at the law in Rule 19 of the Supreme Court rules, the case of Trusted Society of Human Rights Alliance versus Mumo Matemo, and Francis Kariuki Muruatetu and another. We are not convinced by the arguments against the admission by the 20th and 23rd respondents. We see no evidence of bias, of lack of neutrality, and therefore, having considered the application against the rules and the law, we make the following orders. The motion dated 1st October 2021 and lodged on 4th October 2021 by the intended amici curiae is allowed. And this is important. The amici briefs attached to the application are deemed as filed, and the applicants shall not make oral submissions at the hearing of the petitions. Parties shall bear their own costs. The second ruling is on the application of Professor Migai Akech to be admitted as amicus curiae. We have looked at Rule 3, 19 to 31 and 50 of the rules, the practice directions of the court. We have considered the grounds in support of the application, the reliance on the case of Trusted Society of Human Rights Alliance versus Mumo Matemo. There is no opposition to the application. Having considered it, we are also of the view that Professor Migai Akech, in his brief, will be of valuable assistance to the court, and we have seen that he has demonstrated expertise in his field relevant to the proceedings before the court. In the circumstances, the application dated 20th October 2021 and lodged on 22nd October 2021 by the intended amicus curiae is allowed. The amicus brief attached to the application is deemed as filed, and the applicant shall not make oral submissions at the hearing of the petitions. Parties shall bear their own costs. The third application is by Professor Richard Albert and Professor Yaniv Rosnai. They have relied on the rules 3, 19, 31 and 50 of the rules. We have considered the grounds on the face of the application. We have read the amici briefs by both Professor Richard Albert and Yaniv Rosnai. Their reliance on Francis Kariuki Muruatetu and Trusted Society of Human Rights Alliance. We have looked at Rules 19 of the court rules, and the two decisions I've just quoted above. We have seen that the applicants intend to address the court on the issue of constitutional amendments relevant, including questions touching on the basic structure, its scope, relevance, and applicability. In the circumstances, we are of the view that the applicant's very detailed amici briefs shall be useful to the court, and therefore we shall allow the application to be admitted as amici curiae. The amici briefs are deemed as filed, and the applicants shall not make oral submissions at the hearing of the petitions. Parties shall bear their own costs. The fourth and last application for admission as amici are by the by Professor Charles Fombad and Professor Adem K. Abebe. They have relied on Articles 1, 2, 3, 10, 48, 159, 160, 164, and 259 of the Constitution, and Rules 19, 1 and 2 of the Supreme Court Rules, as well as the affidavit sworn by Sally Omoto, advocate. We have looked at the amici briefs. They have detailed a number of questions for Professor Fombad. He has asked 3 questions that he wishes to address, and Professor Debe has similarly raised 3 questions which he wishes to address. Having looked at the law, Rules 19 of our rules, the cases of Raila Odinga and others versus IEBC, Trusted Society of Human Rights versus Momo Matemu, we are of the view that the admission of the amici curiae will be useful in achieving our mandate to develop the law with the assistance of input from parties appearing before us. And we find that the amici have filed a detailed brief which shall be of use to the court, and therefore we shall admit their application, we shall allow the application, admit them as amici curiae. The briefs attached to the application are deemed as filed, and the applicants shall not make oral submissions at the hearing of the petitions. Each party shall bear their own cost. Thank you, Honorable Chief Justice. Thank you, judges. Thank you, Counsel.
Thank you, my Lord, Justice Renaura, for delivering the 4 rulings on behalf of the court. I will now ask the Honorable Mr. Justice Ouko, Supreme Court Judge, to read the ruling on the application for consolidation.
Thank you, my Lady Chief Justice. It's a straightforward application. It's brought by way of notice of motion by Dr. Duncan Oburo Juang, Dr. John Osogo Ambani, Dr. Linda Musumba, who are seeking leave to consolidate petition numbers 11, 12, and 13 of 2021. Upon perusal of the affidavit of Duncan Oburu Ojuang, and upon perusal of the response by those parties who have filed their submissions in this application, which is essentially not opposed, and being guided by this court's decision in the case of Law Society of Kenya versus Center for Human Rights and Democracy and 12 others, and considering the provisions of Rule 12 of this court's rules, we have no doubt that the application meets the threshold for consolidation. We further find that petition number 12 of 2021, the Attorney General versus David Day and 73 others, encapsulates most of the key grounds common to the rest of the other petitions, in contrast with the appellant's petition number 11 of 2021, which raises a single issue. The order of proceeding of President's proceedings and presentation will be shortly given by the presiding Chief Justice, but we make the following orders in regard to this application. Number 1, that petition number 11 of 2021, Morara Amoke versus His Excellency Uhuru Muigai Kenyatta and 83 others, petition number 12 of 2021, the Attorney General versus David Ndei and 73 others, and petition number 13 of 2021, IEBC versus David Ndii and 81 others are hereby consolidated. Petition number 12 of 2021, the Attorney General versus David Ndii and 73 others, will serve as the lead file in the proceedings, save to add that they will need to add all the parties that are omitted. For instance, Mr. Ochiel's clients, Dr. Mwimali and Muhuri, and any other that may have been omitted. Those are the orders of this court. Thank you, my lady CJ.
Thank you, my Lord Justice Ouko, for delivering the ruling on behalf of the court. Having delivered the 7 interlocutory rulings arising from the 7 interlocutory applications, the 3 petitions are now consolidated, and the read file is petition number 12. We will now proceed to give directions for the hearing of the petitions as consolidated. In light of the above decisions, the directions of this court with regard to disposal of the consolidated petitions are that petition number 12 will be the read file. The petitioners in the 3 respective petitions will be the appellants, while the rest will be the respondents. At our preliminary review of the record, we have been able to discern some issues which will guide counsel on the filing of the submissions, and I will request my brother, the Honorable Mr. Justice Ibrahim, to read those issues. I also wish to hand, if any party feels at liberty to hand another issue, they can do so.
Thank you, my Lord, the Honorable Chief Justice and President of the Court. The Court has considered, having read the record thoroughly, the issues raised in the petitions. 3 petitions were lodged in the Supreme Court challenging the judgment of the Court of Appeal in Civil Appeal number E291 of 2021 as consolidated with E292, E293 and E294 of 2021, delivered on 20th of August 2021. A summary of the issues raised in each petition is set out herein below. 1. The basic structure doctrine is whether the basic structure doctrine is applicable in Kenya. If so, the extent of its application, whether the basic structure of the Constitution can only be altered through the primary constituent power, and what constitutes as the primary constituent power. This emanates from the petition by the Attorney General. 2. Whether the President can initiate changes and or amendments to the Constitution, and whether a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 of the Constitution, or through a popular initiative under Article 257 of the Constitution. This again emanates from the AG's petition. 3. Whether the second schedule, the Constitution of Kenya Amendment Bill 2020, was unconstitutional. Once again, This is from the Attorney General's petition. 4. Whether civil proceedings can be instituted against the President or a person performing the functions of the office of the President during their tenure of office with regard to anything done or not done contrary to the Constitution. This is also an issue emanating from the Attorney General's petition. 5. The place of public participation under Article 10 vis-a-vis the role of IEBC under Article 257(4) of the Constitution, and whether there was a public participation in respect of the Constitution of Kenya Amendment Bill 2020. This issue emanates from both the petitions of IEBC and the AG. 6. The interpretation of Articles 88 and 250 of the Constitution with respect to the composition and quorum of IEBC. This comes from the IEBC petition. And finally, 7, the interpretation of Article 257, sub-Article 10 of the Constitution, whether the interpretation of Article 257, sub-Article 10 of the Constitution entails and or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referenda questions. This comes from the petition of Morara Omoke. Thank you, Honorable CJ.
Thank you. Those are the issues we discerned. I will proceed to give the other directions. Those are the issues that will guide on the written submissions. The other direction is that the applicants are hereby directed to file and serve their written submissions and list of authorities on those issues framed, but they will be at liberty if they feel there is an issue they need to hand. They will file their submissions within 10 days from today. The applicants, 10 days. The respondents are also to file and serve their written submissions and list of authorities within 10 days of the service of the applicant's submissions. In the event the applicants wish to file a reply, they will be at liberty to do so within 5 days of service of the respondents' written submissions. We also wish to direct, pursuant to the practice directions of this court, that all written submissions shall be in double line spaced, font size 12 times New Roman font type, and should not exceed 15 pages. Lastly, the consolidated petitions shall be earned on 3 consecutive days. That is on the 18th, 19th, and 20th January 2022. Those are the directions of the court. Thank you very much.
If it may please the court, Chief Justice, I do agree that the court has made directions, but we were of the considered opinion that the number of days is rather limited, and we were requesting that it be extended by another 5 days, at least 15 days, because of the voluminous nature of the issues to be considered. on this matter. And the other issue we were requesting for court's reconsideration on was the issue of number of pages. And this is because in making our response, we have to consider all the amicus briefs which have been submitted, and of course the decisions which have been made. And I was thinking that anything less than 30 pages would be very, very limited on the part of the main petition. Those are the two requests I wish to make, of course taking into account that the court has made directions, but I would request that if possible those two issues be reviewed. Thank you.
Did I hear like you asked for 5 days instead of 3 days?
15 days minimum, my lady. 15 days. How many?
Senior Counsel, how many days?
15 days for filing your submissions. Okay. Okay.
May it please the court, I stand to concur with my learned senior. To the court.
We concur in that request, but also have another difficulty. We are omitted from what is now designated the lead file. We need to be given a number on that file so that we're able to make our responses. Thank you.
Thank you, Honorable Chief Justice. My request is to have directions on the time allocations for the oral presentations. Thank you.
Good morning, my ladies and my lords. My name is Mwoki. I hold brief for Mr. Kanjama. I was requesting for directions in petition of appeal application number E17 of 2021. It's a notice of motion application. My name is Mwoki. I hold brief for Mr. Kanjama. I was requesting for directions in notice of motion application number E017 of 2021, filed on 1st of October 2021.
An application on what, please?
My lady, the application was for consolidation and waiver of the requirement to supply physical copies of the record of appeal.
So the directions we've given or the ruling on consolidation doesn't capture that?
It does not capture that, my lord.
The ruling on consolidation has already been given. The petitions are all consolidated.
Very well, my lady. I stand guided.
Yes.
Honorable Chief Justice, I have confirmed the Deputy Registrar. That application was never filed. It was submitted but returned by Mr. Kanjama, if I'm not wrong. It was not on the record.
I stand guided.
Confirmed, Mr. Kanjama. It's not on the record.
Very well.
My Lady, the Chief Justice, my lords and my ladies, may I humbly request that you expand the pages from 15 and make them 40. This will go a long way to reducing the time that all of us will spend in the oral submissions. That is my humble request. Sorry, my lady, the Chief Justice, yes. I was requesting that the number of pages be increased from 15 to 40. so that we reduce on the time that we'll spend during the oral submissions.
40 pages. Yes, you will allow us to adjourn for only 10 minutes so that we consult and come back on the ruling on those issues.